and at the same time respect the constitutional right of the Kenyan people to have information as quickly as possible. This is a petition that stands for dismissal. And as I sit down, this is one of the petitions that we ask you dismiss with the costs.
Thank you. Thank you very much, Mr. Mwite.
Thank you, my lord.
Yes, Mr. Ngatia.
Thank you, my lord. My lords, within the time we've had, we'd wish to discuss or submit and limit our submissions to the first document, annexure number 4, the scrutiny of forms 34Bs. My lords, I start off with the constituency Kisauni is indicated as if the returning officer did not sign, but it was signed by the agents. Our comment on that is this: please verify with the 34B that was submitted to the court, because we have looked at a copy and the copy is signed by the returning officer. There could be errors in this document, but it's important the court to verify. And as the court is verifying, allow me to say this: the petitioner had 56,000 votes as compared to the third respondent who had 17,000 votes. And I don't think I need to say anything more. That is a constituency where it is the petitioner who had more votes than the third respondent. The next is Nyali. In Nyali, again, it's indicated returning officer did not sign, but 2 agents, one of ODM and Jubilee, have signed. Once again, my lords, I request the court, before making any decision on it, to verify with the 34B that was submitted to the court.
Where are you reading?
Scrutiny of Form 34B, Schedule 4. Schedule 4.
Schedule 4, okay.
I am now at the middle of the page, Mombasa, Nyali. And as regards Nyali, my lords, the person who garnered more votes is the petitioner at 41,000 against the third respondent with 19,000. Once again, I do not need to amplify any further. If that vote was to be discounted, to whose prejudice that would be. And finally, Likoni, it would appear all these problems are in our coastal town. In Likoni is again indicated as if returning officer did not sign, but 8 agents signed. In Likoni, my lords, petitioner got 38,000 votes as contrasted to the third respondent who managed 10,000 votes. Again, the consequence should be as clear as day follows night. My lords, apart from that, most other 34Bs have been signed by returning officers and by the agents. A great majority of 291 34Bs have all been signed by returning officers and by the agents. What does that demonstrate? It demonstrates 2 things. First and foremost, my lords, the fallacy that many 34As were missing is untrue. All the 34As were used to generate 34Bs. And we know that because from the polling station, the 34As would go to the constituency for collation verification, and compilation of 34B. Next point, my lords, we left this court with a very sensational submission that IEBC took some time to go and now correct all these documents. Correct the documents so that they are all very well collected and well presented. That cannot be true because you see there are still some errors in the documents. So that sensational comment goes through the window. Third point, my lords, there is no allegation that the votes in 34A differ with the votes in 34B. There is no numerical difference. There are some instances, my lords, and I think we all need to see those instances, where due to certain difficulties, for example, Isiolo South, the 34B is not signed because the printer broke down. RO had to travel 150 kilometers to prepare that document. I am reading what the registrar has captured. The comment, while that form was not filled by the agents, is because the printer broke down, and it's all indicated there. My lords, in our submission, this fortifies what we have said all along. Fortifies what we have said all along, that this was a fairly credible election within the parameters of conducting an election. My lords, I go to the IT, and before I go to the IT, my lords, the final comment on the scrutiny, there is no allegation that the vote announced at the polling station differs from the vote in 34A. So with all those, my lords, the only conclusion one can reach in my submission is that 34A as well as the 34B correctly reflects the votes cast in favor of all the presidential candidates. And I repeat here, my lords, that the on-reforms 34Bs that on the face of this appear to have a problem are actually where it is our political opponent who had more votes than the third respondent. So we would not wish those to be taken away because that to us is purely a clerical error. If the returning officer did not sign, it was a clerical error. But we tend to think that actually the returning officer must have signed for the agents to have signed. And we see in one of them, 8 agents have signed. My lords, I go to the IT. The IT report has a few errors, and we request the registrar, in the fullness of time, to compare this report with the handwritten notes that were done by our representative. Because in certain instances, what is here does not marry with what our representatives were requested to sign for. And they signed for each and every part of this report. I start off, my lords, at page 7. Page 7, letter H. And then towards the bottom of that page is court-appointed IT experts. Documents submitted were not certified. My lords, the note our representative made is that the certificates were provided. Certificates were provided. On the next page, my lords, right on top, against the expert who was working on behalf of the registrar, right on top, again, there is the comment, documents submitted were not certified. That is incorrect because the certificates were provided. And as a matter of fact, the annexures to this document are the report or the document that was signed by our experts, and they actually said on that, we have seen the certificates have been provided. Maybe because of the hurry of doing this, there was no time to edit this report. My lords, at page 10, we start having a bigger problem. At the middle of the page, 3.14, our expert has instructed me that where it is indicated against the third respondent that there was no comment, that is incorrect. The correct position is that our representative was satisfied that the soft copy fulfilled the order. So as against the no comment, the correct position is that our representative was satisfied that a soft copy fulfilled the order. And equally at the bottom of that page, the same position holds true, that our representative has signed against the schedule that the court, the registrar provided, that we were satisfied with the order. I turn to page 12. Page 12, about the scanned and transmitted copies of Forms 34A and 34B. And the comment I have from our technical team is that...
My Lord, I was not allowed to put a document. Mr. Ngatia is now giving evidence. Mr. Ngatia, my learned friend, is now giving evidence of what his experts have told him, and is not part of the report. I don't think he can be allowed to do that.
Perhaps let me repeat.
He can comment on it, but he cannot rebut the report on the basis of what he has been told, because that is not his duty as counsel, to give evidence.
Let me repeat, maybe I wasn't clear to my learned senior. I say that there are annexures to this report. The annexure is a document that our representative has written, handwritten notes.
It's not here, my Lord. We have a report which you have been given by the court. And that annexure was a strange document, which we don't have.
No,
we don't have it.
Maybe the judge could indicate.
Maybe there's something happening somewhere.
Too suspicious.
Finish off, Mr. Ngatia.
Yes. I'll finish off, my lords, because I was coming to the conclusion at page 13, and our comment on the conclusion is that there are three comments we'll make on that conclusion, because in one respect we differ with it. My lords, the first respondent, that is IEBC, notified us, as well as the petitioner, that the read-only access would be made available today at 5 p.m. Petitioner requested for admin rights at that meeting. That to us was beyond the order that was made by this court. Admin rights, my lord, is not something that parties were given. We were given read-only access. We cannot expand the terms of the order because it becomes now suitable for one party to expand the terms of the order. The next one, my lords, is our disagreement with the sentence reading partial access became available after the meeting had been called. First respondent had indicated if granted more time. First respondent did not request for time. On the contrary, the person who requested for more time is the petitioner. My lords, apart from that, we have no difficulties with the other contents of this report. It is a fair report given the time and the urgency that the matter had to be attended to. And once again, my lords, it is our submission that this report fortifies what we have said all along, that indeed this was a fair election where integrity of the vote was protected to the last, as far as humanly possible. I conclude. The totality of this exercise, my lords, would establish beyond any argument that contrary to what has been a recurring theme about missing Forms 34A, nothing like that ever happened. All the 34As have been accounted for to the last one. And they were accounted for at the right time